Welcome to the special Brennan Center for Justice event, everyone. For those of you joining us today for the first time, the Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and to defend our systems of democracy and justice so that they work for all Americans. I'm your moderator for today, Wilfred Codrington, Associate Professor of Law at Brooklyn Law School and the Dean's Research Scholar there. I'm also a fellow at the Brennan Center for Justice. Before we get started today, there are just a few housekeeping notes. The Brennan Center for Justice is a nonpartisan organization. So while it cannot support or oppose any candidate for office, it can and it will vigorously debate the policies and the positions that matter for our democracy. Civility is also important to us. So for those of you who post rude or intemperate language in our message here on YouTube or in the Facebook channel, you will be removed from the conversation. Live closed caption will be provided, and you can also follow along on social media with the hashtag Brennan Center Live. Now for today's program. The right to vote is the most vital piece of the democracy puzzle. But you may be surprised to learn that in the United States, voting isn't actually a right, or at least not one that appears in the Constitution. This makes our federal government an outlier among most peer countries, including Germany and Canada, for example. Now, generations of Americans have experienced the same conflict. Disenfranchised groups fighting for their right to cast a ballot. Now, today, this struggle continues with attempts to prohibit some Americans from voting, such as those with criminal convictions, and to deter others, including minority groups. A new book, A Real Right to Vote by scholar Richard Hasen, argues that a constitutional amendment guaranteeing the right to vote is the solution to end this perpetual struggle for the ballot. Is it that simple? Well, luckily we have the author himself here to answer all of our questions. So allow me to introduce Rick Hasen, Professor of Law and Political Science at UCLA and the Director of the Safeguarding Democracy Project at the law school there. Rick is the author of A Real Right to Vote. And Rick, we thank you so much for joining us today.
Well, Wilfred, it's so great to be with you, especially because I've been a big fan of your work on the existing parts of the Constitution, especially those that provide some protection for voters.
Well, thank you. That's kind of you to say, Rick, and I'm a big fan of yours as well. So let's get to some questions. Rick, so some of our audience members are going to be surprised to learn that the right to vote is not actually guaranteed in the Constitution. Can you just start out giving us an overview of what that might mean, especially for those of us who think of this right as so fundamental for a democracy?
Right. A big part of the puzzle here, understanding voting rights in the United States, starts with the truth that our Constitution is very old. So if you go back to the 1780s, when the Constitution was being written, there was very little thought of universal voting. There were property restrictions. There were restrictions based on race. There were restrictions based on gender. In the U.S. Constitution, voters were not given the right to vote for president. They were not given the right to vote for Senate. Voters didn't get that right until the 17th Amendment at the beginning of the 20th century. Even for the United States House of Representatives, where an election was to be held, the qualifications for voting were to be set by states. So the initial Constitution didn't really say anything about voting other than that it didn't protect voting in any affirmative way. Over time, different amendments to the Constitution have been added to prevent certain discrimination in voting. So if you're going to hold an election, the 15th Amendment says, don't discriminate on the basis of race. Or the 19th Amendment says, don't discriminate on the basis of sex, but no affirmative right to vote. And as recently as 2000, in the controversial Supreme Court case of Bush versus Gore, the Supreme Court affirmed that not only do voters only have the right to vote for president because of the grace of state legislatures giving them that right, but that states could take back that power and let legislatures choose presidential electors in future elections at any time. So our right to vote is far from guaranteed in the current Constitution.
That's amazing to hear. I mean, the fact that we can have this right, we bank on having this right, and that they can just take it away from us at any time. I'm going to follow up, just ask you maybe to speculate a little bit, whether we think of America as a democracy or republic. We both know as election scholars that voting is something that underlies either of those systems. So if that is the case, why wouldn't the right to vote have been put into the Constitution in the first place?
If you go back to the struggles over the various amendments to the Constitution, for example, you go back to the 15th Amendment. 15th Amendment is one of the Reconstruction Amendments. It's one of the amendments that came after the end of the Civil War. 13th Amendment abolished slavery. 14th Amendment did a bunch of things, including providing that states can't deny people equal protection or due process. And the 15th Amendment that barred discrimination in voting on the basis of race. That was, at the time of the 15th Amendment, the first time there were serious proposals to have universal voting, at least for citizen, adult residents, and people without felony convictions. And it failed because even though there was a supermajority of Congress and state legislatures that were willing to say no discrimination in voting on the basis of race, there were still thoughts of discrimination on other bases against immigrants, against women. There was I talk about a case in the 1870s where a woman named Virginia Minor, who was a resident of Missouri, argued that the 14th Amendment, which guarantees equal protection and guarantees the privileges or immunities of citizenship, this meant that she couldn't be discriminated against in voting. And the Supreme Court, in a case called Minor versus Happersett, said, you're a citizen, but you do not get the privilege of voting under the Constitution. That's a matter of state law. So we have this, long struggle. And so it's really been when the franchise has been protected, it's mostly been through the actions of Congress and through the people. There's only one small period in United States history in the 1960s under what's often referred to as the Warren Court, where the Supreme Court of the United States was really protective of voting rights. So it really is a history where the right to vote has never been easy. It has never been automatic. It's never been universal. And for each class of people, it's been a struggle over who gets that right and how that right is to be exercised.
Yeah. Well, I want to follow up with a question that sort of I hinted at a little bit in my intro, which is that other countries do have a right to vote enshrined in their constitution. And I'd love to get your sense of if they struggle with this sort of voting issues and the problems that we have in the same way.
Yeah, I think the answer is that, no, we're unique. So the United States is going through a period of great political polarization right now, but that's common in many democracies around the world. You can look at Brexit in the UK. I mean, you can look at disputes in France. You can look all over the world and you see these fights. But what you don't see is a huge amount of litigation over who gets to vote and how they vote. The United States is unique in that way. And I think a big part of that reason is we don't have something like what's in these other constitutions that says if you're over the age of 18, sometimes it says, and you're mentally competent, sometimes it says, and you're not currently incarcerated, then you are entitled to vote in all elections in the area in which you live. And so that is, I think, a big part of the reason that every 4 years we kind of have a national panic. Are we going to be able to hold free and fair elections? Are there going to be fights over what the rules are? A big part of the reason why this happens is a very fundamental one, that our Constitution does not affirmatively guarantee that right to vote.
Hey, Rick, something I really like that you do, and I always tell my students that the cases don't focus on the people at hand, right? We think about doctrine, we think about these principles and rules, but rarely do we really look at the people behind these actual cases. And these impact people greatly. So in your book, you highlight this through the stories of people, both past stories and you tie them to current stories, sort of showing the problems throughout our history. One such example is in 2022. You highlight an example with Governor Ron DeSantis, and he announces the arrest of 20 voter fraud suspects. And you write that he said that he was targeting former felons in heavily Democratic counties. Maybe you can talk about that specific event, and maybe you might tie it to something else in the past.
Right. So, the way that things look today is somewhat different than how they looked in the past. In the past, we had outright disenfranchisement. So I mentioned the passage of the 15th Amendment. Let me just go, before I turn to the DeSantis example, let me go back in time to 1903, when a man named Jackson Giles went to the Supreme Court and said, I'm a citizen adult resident of Alabama. I should be allowed to vote. I'm a male. Men are allowed to vote. I'm not being allowed to register to vote because I'm Black. And the 15th Amendment bars discrimination in voting on the basis of race. And so let me vote. And the Supreme Court said it's true that the 15th Amendment bars discrimination on the basis of race, but there's really nothing we can do about it. We have no power out of Alabama. It was really an abdication of the Supreme Court's responsibility. So, back in 1903, there was out and out discrimination on the basis of race and along other categories as well. It was not until Congress passed the Voting Rights Act of 1965 and the Supreme Court upheld its key provisions in cases beginning in 1966 in South Carolina versus Katzenbach, where we actually had the meaningful enfranchisement of African-American voters in the South. And yet today, what we see is something different, which is that impediments are put up in front of voters, despite the fact that Congress, through the Voting Rights Act and the Supreme Court, in a series of cases in the 1960s, greatly expanded our understanding of voting rights. There are still some prohibitions that are allowed. One of those prohibitions is on the basis of having committed a felony. Now, that's a rule that gets decided state by state. There's nothing in the Constitution that requires the reenfranchisement of people who've completed their felony convictions. Most states have put that in place, but not every state. In Florida had a very strict felon disenfranchisement rule. It essentially lasts for a lifetime unless a governor gave the restoration of voting rights. Well, the voters of Florida, Republicans and Democrats and independents, didn't like it, and on a supermajority basis, passed a constitutional amendment to their state constitution that reenfranchised former felons when they completed their sentences. In doing so, they meant, I think, the voters of the state meant to say that people who've paid their debt to society should be brought back into our social society and given that right to vote. But we saw two things happen. One was the state legislature passed a series of implementing laws that made it harder for these people who had formerly committed felonies to be reenfranchised, because they would have to pay all of their fines and fees in order that they might owe from their earlier criminal convictions. They'd have to pay those, otherwise they would risk a new felony. And Florida had no system in place to tell former felons whether or not they had fines and fees that were outstanding. This case was litigated all the way to the United States Court of Appeals for the 11th Circuit, and the court said, well, tough luck. The state doesn't have to tell you if you're enfranchised or not. I mean, really horrible decision. So that was one thing that happened. The other thing that happened was when that amendment was passed, it included an exception for people who were convicted of murder or convicted of certain sex-related crimes. The people who were arrested in Florida in this, these raids that were happening, in the middle of the night with a lot of fanfare, Governor DeSantis was trying to get a lot of attention for this. The people who were arrested were people who had sex-related convictions and sex crime-related convictions and had not and had registered. One of them I talk about in the book had been invited to register by the local voting office because they saw that he was a felon who had completed his sentence, and they weren't paying attention to this exception. a lot of these charges ended up getting dropped because in order to be criminally convicted, you have to have a certain mental state. You have to be willfully violating the law, but people didn't understand that the law had this exception. And in contrast to the great fanfare that Governor DeSantis announcing these convictions, he did very little when it came to double voting, confirmed double voting by voters who were mostly Republican Trump supporters living in the villages, an affluent, mostly white area in a different part of Florida, who voted both in Florida and in their states where they came from. You know, a lot of people live part of the year in Florida, part of the year in another state. These voters were not brought out. Some of these voters who voted twice were looking to get community service. They weren't looking to be facing a felony. And so there really is a double standard, even when it comes to enforcing the kind of patchwork of election rules that we have in each state. And those patchwork often leaves people who've been on, the lower end of society who have faced greater impediments. They're the ones who are most likely to face criminal consequences for trying to exercise their right to vote.
Every time I hear that story told by anyone or read more about it, it just gets my blood boiling. But I do want to follow up on that point. You notice you said that this is a patchwork, so states can make their own decisions. We have a couple states, I think it's Vermont and New Hampshire, that even allow people who've been convicted of crimes to vote while they are incarcerated. DC also does that. Of course, DC is not a state, which presents its own issues with democracy. How does this work in other countries? What do other countries do about people convicted of felonies?
Well, there is variation, and I don't go into the details of this in A Real Right to Vote. But in Canada, for example, the Supreme Court of Canada interpreted their equivalent of their U.S. Constitution, their Charter of Rights, to ban felon disenfranchisement across the state, even for those who were currently serving. So the United States is more of an outlier on this question, but there are variations on this issue. I should say that until I started writing this book, my view was that it wouldn't be necessary to have a constitutional amendment dealing with the question of former felons, because I think it's always better when these rights can be first attempted to be put in place through popular decision-making, through legislatures or voters acting through the initiative process seeking to restore rights. And in fact, in the United States, the unmistakable trend is towards greater enfranchisement of people, at least who have completed their sentences. And yet, after studying the Florida case and seeing the kind of recalcitrance that there is, it convinced me that we need to do something. It reminds me of something you talk about in your book, The People's Constitution, the fight over the poll tax. In the 24th Amendment, the United States banned the practice of making people pay in order to be able to vote, but it applied only in federal elections. Well, what about state elections? Well, in Harper versus Virginia State Board of Elections, Virginia was one of only 4 states that still had poll taxes for state elections. And the Supreme Court, this was during that Warren Court period when the court showed kind of surprising protection for voting rights, said that for those 4 outliers, those 4 states that were remaining, it was going to be unconstitutional under the Equal Protection Clause to continue to have a poll tax, because the payment of money or wealth or property ownership should have no connection to someone's ability to vote. Hard to imagine the Supreme Court today, which is very different, much more conservative, much more looking for more explicit protection of voting in the Constitution. Hard to imagine they would decide the case the same way today. So some of this can happen through the courts. Some of this, probably more of this is going to have to happen through the political process.
Yeah, no surprise. This court is frustrating settled precedent that's been settled for quite a while. So we're not going to bank on them. But what we are going to do is we're going to turn to a video question. We're going to turn to Alicia Bannon, who is the editor-in-chief of the State Court Report, the Brennan Center's project that focuses on state constitutions and state courts. And she's going to ask a question.
Nearly every state constitution includes an affirmative right to vote. To what extent are those guarantees filling the federal gap that you're talking about? And how would your proposed amendment to the U.S. Constitution interact with those state-based guarantees?
Well, this is a great question. So we talk about how we've talked about how in the original Constitution, the question of who could vote for the House of Representatives, the United States House of Representatives, was left to be the same qualifications as applied to people voting for state legislatures. So every state had to have rules for who could vote. Talked about how in the 1870s, the Missouri Constitution did not allow women to vote. Right? You had to be a male in order to vote. So it's true that every state constitution has some protection for voting rights, but how broad those protections are and how widely they are read, often the kind of right to vote that is written in a state constitution is written in a very vague way, kind of like how the Equal Protection Clause appears in the United States Constitution's 14th Amendment. And so the question of how broadly or narrowly to understand the meaning of a state constitution's right to vote depends on how the state Supreme Court has interpreted it. So in some states, unsurprisingly, as you might expect in our federal system, there's very broad protection for voting rights. And in some states, there's very narrow protection for voting rights. And so what states do today is not enough, especially when you look around and you see states putting in place impediments for people to be able to register or vote. It's very rare that those are challenged as violating the state constitution, because state constitutional provisions typically, at least in states that are imposing more restrictive voting laws, don't explicitly reject efforts that make it harder for people to register or to vote. Now, on the second part of Alicia's question on the relationship between state constitutions and the U.S. Constitution, I want to go back to that story of Virginia Minor in the 1870s. She was the woman who went to the Supreme Court and said, they're not letting me vote, and this violates the 14th Amendment because I should have the same privileges as a male citizen has. And when the Supreme Court rejected her argument and said this was a matter of state law, we saw state constitutions being amended. The fight went state by state. And so over the next 4 decades, by the time we get to 1920, when the 19th Amendment is passed by Congress and ratified, barring discrimination and voting on the basis of sex, 30 state constitutions had been amended to allow women to vote, to bar discrimination and voting on the basis of sex. So by the time we got to the National Amendment, it was kind of a done deal because this had already been done in the states. And I see the passage of a more general affirmative right to vote as proceeding in the same way. We can organize state by state, seek to strengthen state constitutions as building blocks toward a greater protection for voting rights in the U.S. Constitution.
Yeah, it's one of the great things about our federal system is that states can always enhance protections, right? And so the federal Constitution operates as this floor. And so that's a great story just to kind of talk about how we got a lot of our voting rights, our constitutions. We looked at what states did and emulated it on ourselves. I do want to go back to a question that or a point that you raised about this Supreme Court. This court, and I guess for the last couple of decades, there's been an increasing number of voting rights cases on the docket. And you said, and I agree, that this court is not the best protector of those rights. Could you talk about some of those cases or instances that make you feel that way?
So let's talk about 2 cases, just as illustrations. One is a case called Crawford versus Marion County Election Board, and the other is a case called Shelby County versus Holder. First case involved whether a very strict voter identification law that Indiana had imposed violated the Constitution's Equal Protection Clause. As I mentioned, in the 1960s, the Supreme Court used the Equal Protection Clause to expand voting rights. But ever since then, it has pulled back on that expansion and actually, I would say, contracted voting rights. One of the arguments that the plaintiffs made in the Crawford case was that Indiana had no good reason for limiting people to having to produce not just any ID, not like a utility bill or something. You had to have a very specific form of ID, like a driver's license. That, of course, impacts poor people who are less likely to have a driver's license, people who've moved, young people who are less likely to drive. And the plaintiff said, make the state produce some evidence that this law is necessary to prevent fraud or promote voter confidence. And the Supreme Court said no. The Supreme Court said, we're just going to take the state's word for it. And in fact, if you look at instances of fraud, and the Brennan Center's, of course, done a lot of work on this, fraud is rare in the United States. But what's extremely, extremely rare is fraud where someone would go to the polling place and pretend to be someone else and cast a ballot in their name, this kind of impersonation fraud. And the Supreme Court acknowledged in the Crawford case that there was almost no evidence. The court had to go back to, I think, 1868 to find some evidence. Maybe there was one case that it referred to in a different state in 2004. Very rare. But the Supreme Court said states don't have to produce evidence. Under what's called the Anderson-Burdick balancing test, those who challenge voting laws have a big burden to show that the restrictions on them are pretty severe in order to get the court to apply a more scrutiny and require states to produce that kind of evidence. So that's an example of the Supreme Court not siding with voters, not putting on a thumb on the scale favoring voters. In fact, the thumb on the scale has favored the state. Second case is Shelby County versus Holder. Here we get into the question not just of the Constitution itself protecting voting rights, but what about Congress's role in protecting voting rights? So when Congress passed the Voting Rights Act in 1965, when it passed important amendments to that act in 1982 and 2006, it did so under its powers to enforce the 15th Amendment, prohibition on discrimination voting on the basis of race, and I'd say also under the 14th Amendment, providing for equal protection. The Supreme Court in Shelby County versus Holder killed off a key part of the Voting Rights Act, even though the court, I believe 3 times before then, had said that the Voting Rights Act was a permissible exercise of Congress's power to protect voting rights. But here in Shelby County, the court said, no, we're going to treat Congress like a litigant coming before us that has to come forward with enough evidence to satisfy us that there's enough of a problem of discrimination in the states to justify this kind of law. And so not only do we see Congress, not only do we see the Supreme Court today not enforcing voting rights strongly in its own right, it's also hampering Congress's ability to enforce voting rights in a strong way.
So the interesting thing about that is particularly about the Crawford case is that the Overton window on this keeps moving, right? So in that instance, you had a state that adopts a very strict ID law, and now we have tons of states that do it, and they're getting even stricter. And at the same time, the court asked for no evidence of fraud, and now fraud is just a blanket justification for any law, and there's no questions asked. So it's interesting how that just sort of builds on itself. I guess I want to follow up here, though. One of the things I teach my students is that the court had such difficulty getting in what it called the political thicket. It did not want to be involved in election-related cases, specifically redistricting, but other ones too. And now you just said that the court wants, claimants to come to them or Congress to kind of justify to it that it's doing what the Constitution say. How do you square that circle?
Yeah, I mean, I think once in the 1960s, the Supreme Court entered the political thicket and agreed to start hearing these cases. It never stopped. So one of the things I've been doing for a long time, and I have updated statistics in my book, A Real Right to Vote, is I track the amount of election litigation. Election litigation has nearly tripled in the period post-2000 compared to the pre-2000 period. Part of that is a function that because we have this highly decentralized election system, and because after the 2000 election, we learned that the rules of the game can matter in a close election, we've seen lots more legislation in states and local governments, and legislation, at least when the legislation changes voting rules, can lead to litigation. And the Supreme Court has not been shy about getting involved in this litigation. As you know well from your piece, Purcell and Pandemic, there were lots and lots of cases during the 2000 election when jurisdictions changed their voting rules to deal with the fact that it was much harder for people to vote safely in person in the middle of the pandemic. Some places, that those changes led to litigation in both state and federal court. And the Supreme Court kept getting involved in that litigation, kept saying, you know what, we're not going to let you change things in the period close to the election because that might cause voter confusion. And as I think you and I both agree, this Purcell principle has put it's another way of putting a thumb on the scale to favor the states over the voters. You know, what we really need is more of a focus from the court on the question of voters and what it is that the courts can do to protect voters. That's not the focus of the court today. If anything, through cases like Abbott versus Perez and Brnovich versus Democratic National Committee, the court has said they're going to presume the good faith of states and really up the burden in both constitutional and voting rights litigation, making it much harder for voters to be able to succeed. That's why I think we can't trust the courts. And in the appendix of my book, A Real Right to Vote, I provide some specific language aimed at courts to stop courts from thwarting the expansion of voting rights.
Presuming the good faith of state legislators. So foxes guarding the hen house. Rick, I want to get a little bit more into the substance of your proposal. And actually you have two, which I think is pretty wise what you do. You seem to provide a baseline that everybody should be able to get behind, I think. And then you have some add-ons. Could you talk about your approach, what you're doing there, and how you think this would advance the right to vote in the United States?
Right. So I divide my amendment into kind of a basic proposal. By basic, it still would be a huge change, but kind of the bare minimum of what it would mean to have an affirmative right to vote. And then some potential additions. And these are all additions that I personally would favor, but I recognize that trying to pass a constitutional amendment in the current political environment is going to be very difficult, and it's going to be a long slog, and there's going to have to potentially be political compromise if you're going to get 2/3 of each house of Congress and 3/4 of the states to agree on an amendment. That's not an easy task. So something like, as we talked about earlier, the reenfranchisement of felons after they've completed their sentences. I carved that off, along with changing the Electoral College, changing how the Senate is created with 2 senators for each state, as well as voting rights for people in United States territories like Puerto Rico, Washington, D.C., Guam, and other places. So what's in the basic amendment? The basic amendment has 6 parts. Just to hit on some of them briefly, people would have the right to vote for president directly, even if we keep the Electoral College system, which my basic amendment would keep. Within each state, the people of the choice of electors would have to be based upon votes of voters in each state. Voters would have to have their votes equally weighted. They'd be entitled to vote in all elections where they are eligible as a resident. Voting laws could not be unduly burdensome. States would have to come forward with good reasons, substantial reasons, and real evidence to support restrictions on voting that target citizen adults, resident non-felons. The protections contained currently today in Section 2 of the Voting Rights Act for minority voters so that they can participate in the political process and elect representatives of their choice. That would be something that would be enshrined in the Constitution so that the court couldn't weaken it and Congress couldn't simply overturn it. The courts would have to defer more to Congress when Congress acts to expand voting rights. And also, and this would get rid of a lot of litigation in the longer run, I would move to a system where states would have to engage in universal voter registration. So register all voters, and working with the federal government, create a system of identification. All of this with the costs borne by the government, not borne by the people, and not limiting it to a limited, strict set of IDs like we saw in the Crawford case, but affirmatively create a system where everyone who is eligible to vote is automatically registered and identified. So if you move from, say, New Jersey to Montana, your voter number would go with you, and they'd be able to remove you from one part of the one state's voting rolls and put you on another state. Putting this all together, it would be affirmative protection. And so when someone is eligible to vote, it's going to be easy for them to register, easy for them to re-register when they move, and easy for anyone to tell whether or not they're ineligible people on the ballot, as is often claimed, and often without evidence.
Yeah, and that last part sort of sits closely to me as a former full-time counsel and fellow at the Brennan Center, now affiliated fellow. The automatic voter registration was a big undertaking, one of Brennan Center's big projects across the country, and we've seen great returns on that. But it seems to me that all of these things that you're proposing seem to be very common sense. So what's the deal? Why the opposition?
Well, I mean, I think there are two reasons. Well, I mean, I guess I'll say there are three reasons. One is we're polarized, so we can't do anything. So I want to talk about the more voting specific problems. Number one, we have a long history, over 200 years, of hyper decentralized voting. We don't conduct a single election for president, or even 51 elections for president. We conduct something like 8,800 elections for president. And people have a vested interest in having that decentralization continue. And so imposing any kind of national standards, even while this would not nationalize or federalize elections, something I personally would favor, but which I don't propose in the book because I think it would just engender so much political opposition. Trying to get this done in an atmosphere of decentralization is very hard. And then the other reason is, I think that there remains in this country, I talk about this a lot in A Real Right to Vote, there remains in this country a divide about what voting is for. So the tradition I come from is one that treats voting as about the allocation of power among political equals. If that's your orientation, then things like poll taxes or residency requirements or race restrictions, all of these things fall out the window. But what if you have a different view of voting, a view of voting as not about allocating power, but about choosing the best candidate? Well, then, if it's about this choice, maybe you want to make voting harder. You want to show that people can run through the gauntlet, or maybe you want to figure out who's most competent to make decisions. Once you start seeing voting as not about equality and more about making choices, this is sometimes the line between a democracy and a republic. I don't think that really works. But if you have a more restrictive view of voting, think voting is more of a privilege, you think voting should only be exercised by people who own property, or people who have enough stake in the election, and we trust ourselves to figure out who that is, then you might favor some restrictions. Leave it up to the states. If some states want to be more restrictive, then that's just fine. So really, that philosophical divide, I think, is hard to overcome. And so I try to argue at the end of A Real Right to Vote that there are things that, and this line, of course, breaks down along liberal conservative lines, and Republicans are going to be less likely to like my proposal than Democrats are. I try and show what's in it for Republicans and conservatives. And I'd say three things. Number one, you can have better election integrity with a system of universal registration and identification. Number two, you're going to make it harder to steal or manipulate elections. It's something that Republicans and Democrats both say in polling that they're worried about. And number three, as the composition of the Republican Party is changing and as it is appealing to more working class voters who are less educated, these are voters who are most likely to be ensnared in restrictive voting rules. And so it actually could be in the political best interest of the Republican Party to make voting among eligible voters easier. I actually think that Donald Trump may have lost the last election because he discouraged people from voting by mail in the middle of the pandemic. We should make voting easy for people who are eligible to vote. And it can be done. It's done in other countries. It doesn't have to be the kind of thing that engenders, these huge fights, these voting wars that have gone on for so long.
I'll get back to my original statement, which is I think it sounds pretty common sense, but, and I'm loving this conversation between us, but we have to get some audience questions in. And so you just raised a point about other countries. One audience member asks, some countries have policies of compulsory voting. Is there a benefit to making voting mandatory?
Right. So among democracies that do this are Australia and Italy. I do think that mandatory voting is something we could consider in this country. Years ago, I wrote an article suggesting that having mandatory voting wouldn't violate the First Amendment of the Constitution, wouldn't be forced speech, because people would have a right to vote a blank ballot. So, you wouldn't have to choose between Trump and Biden or whoever. You could just go in, cast a blank ballot. But, the question is universal voter registration enough? And I think taking the position of universal voter registration, everyone has the right to vote, is kind of a more middle path than requiring everyone to vote. It's, I think, a debatable point. The United States really doesn't have anywhere with compulsory voting. Before we would make a change like that, I'd like to see some states experiment with it. I think you can make an argument for it, but if you're going to say that people are, able to cast a blank ballot, they're able to, effectively not vote, then a system of universal voter registration should accomplish much of the same thing, because it would say you are registered, you are identified. If you want to vote, you can vote. So, I don't see as much of a benefit to it. But, if someone wants to try it, California, we've got an initiative process here. You want to pass a state constitutional amendment making voting mandatory and give it a try here? Be interested to see what that would look like.
Yeah, there are going to be a bunch of initiatives on every California ballot. So let's see what you have, California. Another question from the audience. Would an originalist take on the position that there is no universal right to vote or universal right to suffrage, since it did not exist in the 18th century? So what would that look like? And could they bring back, states bring back like property qualifications and other things that were permitted in the past?
So, certainly if you looked only at the initial Constitution, there was no prohibition. There was no property voting restriction. We had poll taxes. So really the question wouldn't be about the original Constitution, but what about subsequent amendments? What about the 14th Amendment? 14th Amendment's Equal Protection Clause. What about the 24th Amendment, which bars poll taxes on the basis of in federal elections, and the Supreme Court's decision, which I mentioned earlier in Harper, which barred poll taxes in state elections? What would an originalist say to all that? Well, here you might have a conflict or some tension between respect for precedent, stare decisis, and what an originalist might say. So an originalist might say that state poll taxes are okay, except for the fact that the Supreme Court outlawed them in a non-originalist decision in Harper. So I don't know what the answer is. And I should say that one of the things that motivated this project was my concern that some of those cases from the 1960s, we've talked about a few of them, there are more, that expanded the right to vote. Those cases were not decided on originalist grounds. And some of them, putting aside the question of respect for precedent, and after the Dobbs decision, we can't always count on the Supreme Court to respect precedent. Some of these decisions could potentially be overturned in the next decade or so. There really is, I was just watching a podcast with Leonard Leo of the Federalist Society. And he said, we've got this really good decade and a half period where we can really change the law now. The Overton window is shifting and lots can be done. And it's like, that scares me in front of a court that doesn't have the same respect for voting rights that we saw from the Warren Court. And so I worry what an originalist would say. Some of this, I don't think an originalist would say you could have poll taxes in federal elections because we have an explicit prohibition on that in the 24th Amendment. But state elections? I don't know. I'm worried. That's why I want to get this conversation going.
Maybe we should be happy and fortunate that Leonard Leo is now focusing on the culture and not democracy, but we'll leave that to others to think about. Another audience member asked, what are the barriers to getting such an amendment passed? And I know you started to talk on them, so I want to hear you give a little bit more to that.
Sure. So just to go over what it takes to pass any constitutional amendment, there's two paths. One path is the path of getting 2/3 of each House of Congress, so the Senate and the House, to affirmatively vote an amendment, and then affirmatively vote for an amendment, and then get 3/4 of state legislatures to ratify. That's a tall order in a country that's kind of divided 50-50 along these politically polarized lines. The other path is to have a constitutional convention. I don't talk much about the convention in my book. There's a lot of talk these days about potentially convening groups of citizens that would propose amendments, which could then be proposed to the states. It's not clear exactly how it would happen. Other scholars have focused on this more. But either way, it's an onerous path. And so, my response, I already gave you part of my response to, why do I think this would even have a chance? One is, I think it could be in the self-interest of conservatives to join with liberals in passing such an amendment. But the other point I would say is that, and this goes back to my answer to Alicia's video question from a little earlier, is that what I'm really advocating for is not an on-off switch. Either we're going to have an amendment or we're not, but a movement that is organized around voting rights, one that would focus on the question of, what does it take to enfranchise more Americans and protect their right to vote? And if that movement starts at the local level, starts at the state level, we can build support for voting rights in state by state and provide those dividends along the way, much like happened with the 19th Amendment. So it's not an on-off switch. If we have a time horizon of a few decades and we think of the kinds of benefits that can come along the way, it's not, it's like, I don't know if you've ever gone on a hike and you look up at the big mountain ahead of you and you're like, there's no way I'm going to be able to climb this thing. But if you just look ahead, like the next 20, 30 feet, you say, all right, I can do that part. I think that's how we have to think about a constitutional amendment. The last time we had a constitutional amendment related to voting that passed was in 1971, before most Americans, before a majority of Americans were even born. We've lost our muscle memory when it comes to passing constitutional amendments. So we need to at least get this back on the agenda as something that we talk about.
Someone who's written a book about constitutional amendments, and thank you for mentioning it before, I wholeheartedly agree with that. We really do. Thank you. We really do need to think about how we get back to amending our Constitution to ensure things like the right to vote and other things as well that are plaguing our democracy and our government structure. So I appreciate that. You said this is a longer term fight, as democracy tends to be. It's unending. What kind of role do you see for young people playing in advocating for this constitutional right to vote?
Well, this is, the future, right? So I don't think that, I'd have to look, but I don't think that Virginia Minor lived to see the day of women enfranchised in the Constitution. Certainly Abigail Adams, one of the founding mothers, she did not live to see that day. So I may
remember
not
the
live.
ladies.
That's right. To see the 19th Amendment passed. I may not live to see the day of a constitutional amendment, but maybe my children or grandchildren would be able to live to see that day. Maybe it'll be your great-grandchildren. But, if we think of democracy, as you said, as a kind of constant struggle and not as an on-off switch, then there's much that we can do. We can start to organize for political action. So who's going to do that? Well, I think, young people are the ones who have the most at stake. They have the longest time horizon, and they've got the, I think when I talked about the two different conceptions of the right to vote, I think more young people today would embrace this idea of political equality. One of the stories I tell in A Real Right to Vote is the story of the struggle of voters at a historically Black college in Texas, in Waller County, Texas, called Prairie View A&M University, and how they have just fought. I tell the story of someone whose father and grandfather had to fight for voting rights because the local jurisdiction had made it really hard for college students who had not grown up in the area to be able to vote. I mean, these are things. You think about the issues that young people care about today. You think about issues like climate change. You think about issues of equity and of fairness in the economy. Things that the things that motivate young people today, they're going to be able to get what they want if they can organize for political power. And organizing for political power means voting. And we know that young people tend to vote at lower rates, and we also know that the biggest impediment to anyone voting is that they're not registered to vote. So adopting something like automatic voter registration would go a long way towards making it easier for young people to vote and to be able to get the kind of substantive change that we want. And I think this is a point worth emphasizing. Like, you and I we're process geeks. We're talking about how it is that we vote. Voting is not an end in and of itself. Voting only matters because it allows the representatives of the people to do the people's work and to make people's lives better. That's why we care about democracy, not because, voting has a value in and of itself. Voting is the way that we express our preferences for who should come up with the policies and the rules that are going to govern us. And, how society is going to handle the challenges of the upcoming decades, it's going to present some really difficult questions. And we should all of us who are eligible should have a say in who the people are that are going to lead us.
And so I just want to follow up on the point about young people and sort of the idea of constitutional amendment. A constitutional amendment is, it's a big deal. And young people, as you said, are sort of less involved. Is there something that they might do to sort of lead up to this, sort of give a little bit more of that muscle memory back? Are there interim steps that you might recommend?
Well, the interim steps would be working on voting rights in each state. So one good example, I talk about it very briefly in A Real Right to Vote, is what happened in Michigan. So Michigan is one of the, I think, 24 states that has the initiative process, where voters can get around a legislature that, in the case of Michigan, it was a legislature that had some pretty restrictive laws related to voting, and they were able to establish a redistricting commission, which I know something you care a lot about, redistricting reform. They were able to preserve voting rights in their state constitution, making it harder for state legislatures to make changes in the future that would restrict voting. So there's a ton of work to be done on the state and local level. And, obviously, the policies that help young people vote are policies that will help to assure that their voices are going to be heard. I was just had in my election law class, I had the top election officials of Los Angeles County and Orange County, and the Los Angeles official was talking about how much same-day voter registration there is here on the UCLA campus. Why is that? Young people are going to be less likely to be registered to vote. They're going to, maybe be thinking about this at the last minute, but they're going to want to be enfranchised, and they have the right to express themselves. They have the right to vote. And so making voting easier, and, those people who register on election day, they cast a special kind of ballot where that ballot's not going to be counted until there's confirmation that the people who register are actually eligible to vote. So we have safeguards in place for integrity. I want to make sure that I get that in there. But everyone who is eligible should be able to cast a vote and have that vote meaningfully and fairly counted. That's not rocket science. I mean, that's just a basic building block of democracy.
It's fundamental. I guess there's not much more to be said there. I do, and since we're at the end of our time, I want to ask you one last question. For those in the audience who, can you give us a departing message? What is one last thing you would like for the audience members to walk away with? Something they might do, something they might remember, something they might say. What would you tell the audience today?
Sure, and this is something that I think is how I end the book, A Real Right to Vote. So what is the one thing I would want people to walk away with today? It's that democracy is not going to protect itself, that we have a job to do. Because we have a decentralized system, we can start at the state and local level. There's a lot of work to be done to improve our democracy. We can look at the Constitution as a end goal, but there's a lot that we can do today to make things better and to make our democracy fairer.
Democracy is not going to protect itself. You heard it from Rick Hasen himself. Well, I want to thank everyone here today. Thank you to our audience for all of your questions. I wish I had time to ask them all and Rick could answer them all. The Brennan Center looks forward to seeing you at future events. To be the first to know when events are announced, please be sure to sign up for the events, the newsletter at brennancenter.org/events. I am Wilfred Codrington III, Associate Professor of Law at Brooklyn Law School and a fellow here at the Brennan Center. Thank you, Rick, for joining us, and thank you everyone in the audience for coming today.
Thank you, Israel.